The last video for week 2 is going to focus on reading 1.7, which looks at the nature of recusal in the United States Supreme Court. So I wanted to at least provide some guidance about what is the nature of recusal, what does recusal mean, and to extend that into a broader sense of who makes rules for the United States Supreme Court and what can Congress do to regulate the United States Supreme Court. So recusal, at least at the United States Supreme Court, though this also refers to other courts as well, is when a judge who is sitting on that court decides not to participate in any particular case. Usually it's for reasons of conflict of interest. And at the state level, there exists a lot of guidelines that suggest to judges and when they should recuse, and including some courts can tell judges that they must recuse in any given case. So what is different about the United States Supreme Court? Well, the United States Supreme Court has, these justices have life tenure, and the Chief Justice of the United States Supreme Court is the head administrative actor over the federal judiciary. What this means is the decision to recuse in any given case is a decision that is made solely by the judge in this case. So when a conflict of interest occurs in the United States Supreme Court, there exists no mechanism by which to force a justice to recuse themselves in a case. The only thing that can be done is to suggest that a justice should recuse themselves in that case. But the only way, that a judge does recuse on the United States Supreme Court is if they decide to do so themselves. So we should ask, who makes rules for the Supreme Court? Because clearly one would think that there should be some rules regarding recusal and conflicts of interest. The problem is the Constitution makes it fairly clear that rulemaking power over which judges get to decide the case and how judges decide cases is up to the court. And so while the United States Supreme Court can make rules on lower court judges, there's no one left to make rules upon themselves. Unless they decide to put forward a rule themselves. And still enforcement would be difficult because we tend to think of Supreme Court justices as one among equals, that they all have the same amount of power. And so the court cannot or chooses not to regulate itself. So the rules of the United States Supreme Court are made by the United States Supreme Court. So what role does Congress or the president have in terms of making rules for the court? Well, the president's only real way to influence the court is through appointments. And that is not an extensive way to influence the court. The president also has another way, and the president can influence the court tangentially through appointing individuals that it likes in the Solicitor General's office. The Solicitor General sits in the Department of Justice, and the Solicitor General's office is the formal legal representative for all cases in which the United States is party before the United States Supreme Court. So since that exists within the Department of Justice under the president's guidance, that institution can attempt to influence the court. But it isn't rulemaking, it isn't binding. It is simply might be persuasive to the court. So the president really has no power over making rules for the court. Now, Congress may have a little bit of leeway here, but they don't tend to use it. See, Congress budgets, and Congress makes the budget for the court. And Congress can request the court to do things with regard to the budget, but Congress is usually very reticent to put any sort of requirements upon the court with regard to their budgeting, because they don't want to seem as if they are influencing or getting involved in making the court less independent, because we think of the United States Supreme Court as the most independent court in the United States. And the idea that Congress might attempt to influence them sort of goes against our notions of what judicial independence is. So really the only authority that Congress has over the court is the ability to determine what the court's appellate jurisdiction looks like. To get an understanding of this, we have to look back to the Constitution. The Constitution says that the Supreme Court has original jurisdiction in a number of cases, and in all other cases, it has appellate jurisdiction up to the approval of Congress. So what that means is Congress can remove the appellate jurisdiction of the United States Supreme Court as it sees fit. So Congress could remove the Supreme Court's appellate jurisdiction in any particular issue area, under any particular law, and in fact, even in totality, the Congress could remove the Supreme Court's appellate jurisdiction. But what it can't do is tell a judge to recuse themselves. So this analysis for this chapter that looks at the recusal practices of judges is interesting because we don't know a lot about what affects judges to choose to recuse themselves or not. And there's not a lot of guidance provided out there about the decision that justices make to recuse themselves. The problem and the reason for that is justices aren't very forthcoming with why they choose not to recuse. And so it's a very nascent area of research. It's very interesting, but we have to take a step back and understand that the United States Supreme Court is a very insular court. It's very protected. It's very independent. But what that also means is the decisions that the court makes and the decisions that the individuals on the court make are also very independent and also very protected. And therefore, understanding why they do certain things is oftentimes beyond the sight of any of us observing it.